यार
they take me not become involved in negotiations with counterparts, with other economic parties present, the given space to execute contract for a period of 2 years from the date of getting access to the market, unless the in-house expertise is employed directly or otherwise by another party in-house for any of the defendants versus the. Let me explain this part.
You are the counterparty.
What we are producing before the court are agreements of license entered into by the plaintiff Nokia with third party. Show to the court that what we offer today established for grant of license was
Yes, sir. Good morning.
similar
Good
to what we
afternoon.
offer third party.
Yes.
Now it's with our third
Yes, sir.
party, we are
मैं उसी कोर्ट में हूँ सर.
definitely not having done. The price of money is whether that
Yes, sir.
such in-house representative of the government entity become part of this club will not negotiate with those third parties.
ओके.
All right.
बट सर इसमें एडवोकेट की वॉइस बिल्कुल भी क्लियर नहीं है, मतलब वो जो बोल रहे हैं समझ नहीं आ रहा है.
All right.
अच्छा.
Okay. And their argument was don't redact and let in-house
हाँ, मैं रिकॉर्ड
experts
कर रहा
be
हूँ
a
सर.
party.
Okay.
Okay.
And you also make
Thank you.
whatever they redact, you will not rely upon them
Right.
in the first example. And when it is still the want to persuade the court, then they still entitled whether they can afford the which will really document and see what's the bad in the record. And this is. Sorry, I thought you finished. And this is in terms of what you also had in precedence of this court, so permitted. May I just show those?
हाँ मैंने तो किया थी.
That was the first place where inter-party judgments in other jurisdictions, where there are such provisions that been agreed between us, was partner by the. First
तुमने इसे नोट कैसे बनाया? जिसका नोट कैसे बनाया? समरी क्या बोला था? वो क्या भेजा था सर? इसी केस का. अच्छा ठीक.
between Nokia and the defendant, same party. And please kindly have the relevant party also has.
Yes.
In paragraph 3 on page 5.
Yes.
In addition, access to the information assistant items 2 and 4 of the table under point 1 is given to the defendant side the following person. Benny Alexander Weiss and other representatives of the defendant so far they are entitled to represent the defense in the present proceeding before the PC as well as assistance of those vigilance in credit. He is already employed with them. The party direct.
Yes. No, what does this order show? This only shows the names of the parties who are constituted. Okay. So this you are relying upon only for the names proposed.
And so that presented legal party specified meaning.
Okay.
And that request order. US Trade Commission.
Yes.
And please kindly have the relevant part in paragraph.
Yes.
On internal page 2 of the order. waiting it to find the report.
Yes.
In the absence of written permission to supplier or an order from the Commission on Administrative Process, any confidential documents or business information submitted in a court of para 2 above shall be disclosed to any person other than one outside counsel for parties to this investigation, including necessary secretarial and support personnel in the counsel. Qualified persons taking testimony involved such documents and information necessary stenographic intelligence personnel and three technical experts to the staff who are employed to the purpose of this litigation unless they are otherwise employed by the sector. Parties, all are employed in domestic. Then most of the other legal companies. Now, please kindly have this. Please kindly now have the order passed by this honorable court.
Yes.
This is the case of digital versus offline. And this is the discussion on page 33, paragraph 49.
Yes.
Please kindly have a relation as paragraph 50. There are several situations which are maybe required to constitute such illustrative examples as said. Currently, others subpara C. The context of IP licensing owner who will basically offer license the things provide any of common meaning of what these entities with their license agreement. SCP on Google. In litigation between a market player and SCP owner disclosing third party agreements to a prospector, authorize the third party, such third party, go into such third parties who is and without their consent, disclosure might be prohibited. The agreements executed by SCP or disclosure. In some jurisdictions, the consent or no objection of third parties required disclosure. To ensure the documents and with third parties make operation, not become public, thus to be third party, establishment of the club is resorted to. And then these kindly have a 51.
Yes.
The context of basically such clubs to directly only consist of external counsel and external experts. The obviously should not consist of those persons who can take advantage of information and directly benefit of the employers of legal impact, whom they represent during negotiations, first to get a competitive edge. In that purpose of going to teach in negotiations with those very parties, the agreements have been disclosed. We need to review of the information to derive in negotiations either the same party or other confidential party. It could also result in disclosure consciously or unconsciously.
So in the facts of your case, it is an SCP matter.
Yes. And please note in paragraph 54, very high court ruler, and I can read that. The next page. 17. Parties to connections to which rely upon documents without connection or otherwise confidential nature who make motion so as to allow immediate access to such documents. In doing so, the court may set out a structure protocol for the establishment and functioning of the club and use appropriate and custom structure protocol of the club, provided is next to N. May approve the structure protocol based on that But then the protocol will be next year every story. And one of the protocol notes were it sets out in paragraph. Each party is nominated not only the three responsible for in-house lawyers, external experts. And there are posters, hierarchical researchers. There are 10 clarifications, paragraph. Can be seen in your house. Part sheet. In-house employees which makes specific publishing book. Digital service is such employees. It's to exclude any in-house work. Further, even if in-house employers are included, there's certain measure of understanding in terms of how products will be. However, such an expectation cannot be made by employees who are directly as thus, in-house employees actively engaged not to be actively excluded from the constitutional party. And then we will go then so points.
Okay.
The ground leaves the.
Yes, at para 15.
I'm sorry. Okay. It is one of the people which may have. The licensing restriction not related to time. In the case of digital versus Oppo, same case. On 5th of April. And if you only have the paragraph 2 on the first page, what is the legal part restriction? In-house.
Sorry, I can't find the paragraph. Which paragraph are you referring to? Yes. This is the proviso that you've reproduced? Yes, you can.
My Lord, Ladyship is aware, my Lord, that this is a case of an SEP. Unlike any other patent infringement, where the patentee, my Lord, wants an injunction against an infringement. This is a case where the patentee wants its invention to be used and reaches out, my Lord, to those who are using it. So it's a more of a collaboration between the patentee and the implementer. Now, the patentee, my Lord, reaches out and says, I'm willing to give you a license on FRAND basis. Now, therefore, the onus, my Lord, whether the license being offered is a FRAND basis or not is squarely and only on the patentee and the plaintiff. Of course, my Lord, whatever they give us as an offer, which according to is FRAND-based, can be disputed by us to say, no, it is not FRAND-based for A, B, and C reason, but at the moment we are not concerned with that. Now, in order to establish that they are giving a FRAND-based offer, they want to rely upon certain agreements. Again, my Lord, it's they who want to rely upon the agreements. However, they want for that purpose a confidentiality club to be constituted, rightly so, because these are confidential documents. But while doing so, they are putting certain conditions, and the whole issue here is whether those conditions are fair and reasonable or they are not. Now, we have absolutely no difficulty in having a confidential club constituted. They have agreed, initially they had reservation. Now they've agreed that in-house members can be part of the confidentiality club. Even the names they have shared with us are fine. They have given 3 names. These are the members of the Munich court. one name we have changed because for internal reason. That's no difficulty. I mean, because we are only seeing who is available for all this. But the difficulty is arising, Lord, in respect of basically two propositions. One, of course, Lord, they say, will give you redacted, we will not give you any copies of the documents. Now, my Lord, this is something which is highly prejudicial to us because if we are only allowed,
Mr. Singh, they are not closing your right. They are just saying this is a beginning. If case you find after you go through that document that yes, this redacted document is a eyewash and it really doesn't serve my purpose, we are reserving your right to come back to the court. You are not closing your right. Your that objection in the reply which you must have framed for this, we'll keep it open because he's keeping it open-ended because right now to have a debate on a document which we have not seen seems a little difficult. So that paragraph of your reply where you have said that redacted information may be required, we'll keep that open.
Very
Why do we struggle with that document we've not seen today?
at the moment,
Yes.
fair enough. Because ladyship will just appreciate. Because a lot of times, what is withheld also may be material.
I agree, but that you will be able to form an opinion after you see the
After
document.
we have seen, so ladyship is keeping that open, no difficulty.
Yes, they have kept it open. We can see that paragraph in your reply, and we can
Yeah.
say that objection is left open, and
Right.
you will.
Now, Milot, but I take it that they will share with us the redacted copies of the documents which they wish to rely upon.
At the time of once the confidentiality club is
Club is
framed
constituted.
and they furnish those documents to you, that is
Yes.
when you will be able to see it and form an opinion that you need further information or you don't need further information.
That's right. But I'm only trying to understand, Milot, what is falling from your ladyship. That
The confidentiality club members will take that decision on your behalf that this redacted information is not sufficient, and then that is when you will move an application.
But I take it that the copies of the redacted documents will be given to us.
Will be given to the confidentiality club member.
When I ask means
Because only then you will be able to make your opinion.
So therefore, we are only left now with one,
अंडा भुर्जी कर लो
which
सिंपल
I don't know press or did not press
लोग
because
He only mentioned two, not redact and in-house experts, and which he said he has already he's taken care of.
so long it is that, it's fine with us. But there is a
अभी कितना
they've
है?
not pressed.
कितना है
Well,
हाइट कितनी है
You should see the draft he's handed over, where
हाइट ही नहीं पता
where according to Mr. Sethi, he has taken care of your concerns.
5-6 हो गई
Mr. Singh, we could.
so let me clarify. Where the concern is coming from. What is the proposal?
Mr. Singh, I can give you the.
मेरी 6 है
It's right. Let's give this back.
हाँ हाँ
Yes. Now, my lord, yes.
right.
This is the bone of contention. Your ladyship will see the names, my lord. The defendants' representatives below that.
वो सब आता है बनाने
Representatives that are
Fish waste
included
सब
as
बना सकता
members
हूँ
of the confidentiality club undertake to not become involved in any negotiations with the counterparty without the counterparty's consent, whose agreement is placed under aegis of the confidentiality club for a period of 2 years from the date of being provided access to the counterparty's agreement, unless the in-house representative ceases to be employed directly or otherwise by any of the defendants or his subsidiaries. So they are saying for 2 years, in-house who are negotiating, not for with them, they are negotiating for the company with everybody else.
Not everybody else. Only the counterparty. If they show you, let's say they show you an agreement with
मेरी भी नानी
X,
बनाती है
with the party X, they disclose that agreement to you, and now you're privy to those terms and conditions. They are saying only with that party X, you will not negotiate, but even that condition will fall
इंडियन
if party X agrees to negotiate
कभी
and
जिंदगी में
says that
प्रोटीन
yeah, I'm all right. Because see, it is only without the counterparty's consent. If the counterparty says I have no objection, then even then you have a look at
और वो
it. You
डाइजेस्ट
can
नहीं
come
हो
back.
पाएगा
Mrs. Singh, you have a look at it. first.
We'll have a look.
Yes, because you're right now
जो भी
reading it along with me. You just read it and
फूड
come back if
एब्जॉर्प्शन
you
होता है
have,
ना
but
उसमें
otherwise
से
there
50%
doesn't
होता है
seem to
और
be
यहाँ पे
any.
99%.
Because we had our
You just point out in the reply to this application where have you reserved your right on redacted documents. I feel that is the only part which we have to preserve.
This was not part of the prayer. This is not a part of the prayer.
Now he's handed over. You have
सुनना तो है
received it.
लेकिन
therefore-
रिकॉर्ड कर
And show me that paragraph of your reply where you have reserved your right of coming back to the court for redacted documents, or you want to frame it that
वो
one
बाहर का
paragraph, just frame it.
मैं
We
बाहर
can
में
pass an order in
मैं
terms.
बाहर खाना ही नहीं
So,
खाता।
so
मैंने
Vinod,
खाया
surely we can do
एक
that.
बार 7
I have
से
not
मैंने खाया, उसके बाद मैंने खाया ही नहीं आज तक। ऐसे नहीं खाया था। हाँ चिकन वाले जो क्रिस्पी वाले आते हैं ना, मुझे नाम नहीं याद है।
I see 3 areas of
हाँ, एक
One
साल
minute.
पहले
This is saying,
चिकन
do you
नगेट्स खा
have
लिए
those
थे,
same
बस।
objections, or this takes care of your objections? Your item 45 and 46 gets taken care of.
अच्छा
Mr. Senior, our district court had raised queries. Sai is looking, sorry, Sai Krishna in the third matter had raised additional.
Yes, that I'll hear him. I'll hear him in 37. But I'm asking you.
Vinod, I would say, Milord, we are all dealing with the same issue here. So, Milord, in case if my learned friend has certain submissions, leadership may take it as also as my submission.
Club is concerned. The first area of
बोला गया वही रिलीजियस
disconnect
रीजन की वजह से।
is their insistence on a 2-year restriction on our in-house representative.
To negotiate with the counterparty.
I'll show my lady that not only is it onerous, but in the very same the same parties are involved in a proceeding before the Unified Patent Court, and there they've agreed that there will be no such restriction. In fact, there is no such restriction. I want to show my lady that. Second, even the order shown of this honorable court, my Lord Justice Dayal's order, that was a consent order, because in those proceedings also there was a corresponding UK proceeding, where in those corresponding UK proceedings the parties had agreed on this restriction. It was for that reason that the parties agreed on a restriction in the OPPO order which was shown to my lords. The second area of disconnect.
But tell me one thing,
Yes.
Mr. Krishna, that in this matter, if that counterparty gives it, because they are all, the only reason they seem to be putting this is because it's a confidential agreement between the plaintiff and the counterparty.
Yes.
They are anyways waiving their confidentiality in favor of your in-house employees.
Yes.
They are only saying if the counterparty also waives that confidentiality in your favor, they have no objection if that party negotiates with them. Please see the way I read it. They are not saying that they are reserving that
I
right.
must confess, we didn't look at it that way.
Please see that. They are just saying without the counterparty's consent, which means if the counterparty gives you the consent, then you're free to proceed with it.
No. What they are saying is that this in-house representative will have a 2-year embargo. My in-house representatives who will look at their third-party agreements.
Mr. Rajgopal, please have a look. Okay, before you and I interpret it, Mrs. Sethi, please. What is the intention of this provision? The count. It is clear then in the negotiations this won't apply. I got this
Please
clarification.
consider this.
Yes.
Consider this. I'll show my lady the order, the corresponding order passed in the UPC, Unified Patent Court. There is no such restriction. And in fact, there is very sound logic why there ought not to be such a restriction. The logic of there being no such restriction is I have a team of in-house people who are into licensing negotiations. Now, if each one of them is saddled with this preclusion that they will not negotiate with any third-party parties whose agreements they've seen, then I need literally hundreds of people on board. It is for this reason. That is why you have a confidentiality club. I'm sworn to secrecy under threat of contempt.
But just tell me one thing, Mr. Rajgopal, how will that secrecy help if you are the same person who is aware of the counterparty's agreement? I'm just asking you.
Different portfolios and the council are different. So, for example, in
Not the council. We are talking. This is first of all not applicable to the council. This is only applicable to the in-house representative.
something else, my lady.
point I'm trying to make for my lady's consideration is that it's the very same internal representatives who are the members of the confidentiality club in the UPC proceeding. There is no such restriction there. In fact, this is completely unknown unless parties agree for good reason. Confidentiality club against my first submission. So the point I'm making, the very same corresponding proceedings, my lady may just look at this order. In fact, the Munich order involving the other defendant was shown. If my lady would look at what they've agreed to in Munich in the UPC proceeding, there is no such restriction.
Okay.
Paragraph 3, my lady would just look at this. This is the 9th July order.
Okay, I'll take it. It's not there. Okay.
My lady may just take it from me that it's not there.
Yes.
Second, this very same plaintiff in another proceeding involving Lenovo has share agreements with in-house representatives without such a preclusion.
Okay.
In India. My lady, please look at this for a moment. Paragraph 3. This is an order dated 24th of February 2020. This is Nokia versus Lenovo.
Yes.
In an SEP scenario,
Yes.
says Mr. So-and-so learned counsel appearing for the defendant has no objection principle to the constitution of...
Which paragraph number and which page?
Paragraph 3, I'm sorry.
Page number?
Page number 1, I'm sorry. Mr. So-and-so learned counsel appearing for the defendants has no objection in principle to the constitution of a confidentiality club, but submits that in addition to counsel representing the parties, 2 representatives of the plaintiffs and 2 representatives of the defendants collectively, and an external expert on behalf of each side may be made part of the so-and-so learned counsel for the is also agreeable to this proposal. No restriction at all. So we have a scenario where there is a dispute between both of us in India and in the UPC. There they don't insist on this. Here alone, for some peculiar reason, they insist on such a clause. That's point number 1.
Okay.
Point number 2, in other proceedings, they've never objected. They've never had such a clause. The only order that they've shown my lady is Justice Dayal's order.
Yes.
That was a consent order because in the corresponding UK proceedings, there was such a restriction. Now, my lady, if my lady would look at my lady Justice Pratibha Singh's order, which is also cited, paragraph 57, while the court did express concern about the composition of a confidentiality club and the restrictions that need to be imposed in terms of an embargo, please look at the club that was constituted. Paragraph 57 of this order, internal page 40.
Para 58. It was recast, so it's para 58.
58, yes.
Yes.
Here, the in-house people were made parties. And this order culminated in Justice Dayal appointing the very same people with the restriction of a 2-year term because the parties agreed and there was a corresponding obligation in the UK. So the point I'm trying to make for my lady's consideration is that quite apart from the fact that Justice Singh expresses concerns with respect to and expresses caution with respect to the composition of a club, a club was created, constituted with in-house representatives. And Justice Dayal's order in the very same matter culminated in in-house representative with restrictions only because in the UK proceedings also there was a restriction. They will not be able to show my lady any other order, at least to my knowledge, where this court at least has taken the view, unless the parties have agreed, that in-house representatives will be saddled with a 2-year term. And lady, I'm saying this with some responsibility. If there is a 2-year
have you sought discovery of these documents, or these are documents that the plaintiff is relying upon?
Indeed, and as Mr. Hemant Singh pointed out, this is a standard and essential patent litigation.
Yes.
It is their case that they've offered their licenses, patent licenses, on a frank basis. Now, if these they have to demonstrate that this has happened on a frank basis, then the onus is on them. So, my lady, as far as this 2-year term is concerned, that's one area of disconnect between us. And our respectful submission would be that, like in the UPC proceedings, there should be no restriction here either. And my lady, I can show my lady several other orders, and I'll just leave it with my lady.
UPC proceedings is the first order.
UPC is the first order, correct?
Yes.
I'll show my lady several other orders passed by this court in SEP cases where no such restriction is there. In fact, my lady, at least to our knowledge, there is no other case where this court has imposed a restriction without consent. And my lady, Rule 11 is extremely instructive. Rule 11 of the patent rules. The Delhi High Court patent rules for patent suits. My lady would just look at Rule 11 for a moment. There is no such embargo of a 2-year term envisaged under this rule. My lady will see confidentiality clubs and redaction of confidential information. My lady has that. At any stage in the proceeding, the court may constitute a confidentiality club or adopt such measures as appropriate, consisting of lawyers, external and in-house experts, as also nominated representatives of the parties, for the preservation and exchange of confidential information filed before the court, including documents as per so-and-so. Such nominated representatives of the parties appointed to the club may inter alia be persons who are not in charge of or active in the day-to-day business, operation and management of the respective parties, so as to maintain the integrity of the information so disclosed. The members so constituting the club shall be bound to desist from disclosing, sharing, or utilizing, including the third party. The court may, upon a request made by way of an application, direct the redaction of such information, including documents it seems to be confidential, and that's the next aspect that I'm just going to come to. If any redacted document feeding, that doesn't. The point I'm trying to make is that this 2-year restriction is completely unknown even to Rule 11. Now, my lady, the other area of disconnect between us is the aspect of redaction. And here, my lady, we had, my lord, a solution which I think will work. What we said was this: let the external members, an ideal scenario would have been in line with Justice Harishankar's judgment as far as confidentiality clubs are concerned, that all members of a confidentiality club have to be given access in an unredacted way. If you're redacting any documents, then you shall not rely on those documents. That's what Justice Harishankar in the Jaumi judgment says. Now, my lady, as far as this case is concerned, we proposed a via media. And the via media we proposed was this. We said that there are external counsel. Please give external counsel unredacted access. Don't give the in-house people access to the unredacted portions. If we feel that the internal counsel, in order that they are able to give us instructions, all in-house representatives also need to see those unredacted portions, we'll then come back to court. Now, what they are proposing is, you look at what is unredacted, and it fell for a moment from my lady as well, that we could come back to my lady if we need to see something. Unless somebody sees what is redacted, we will never know whether it's relevant or material, because it's simply blacked out. We won't know what the nature of the clause is, what the contents of the clause.
And tell me one thing, if it is so dark and it's so unreadable, if they are, because they have said they will only be relying upon that dark document, then what relevance even will the court, how will the court also rely upon it?
I'm grateful.
Yes.
I'm grateful for this question.
Yes.
Really, the reason why this becomes important is, let us assume for a moment, what is redacted contains, for example, discounts, contains other commercial information which may have a bearing on what the ultimate license fee in those license agreements are. Then me, as a potential licensee, I should be entitled to the benefit of those discounts or clauses as well. I today, I'm completely blindsided as to what those contents are, whether anything there, volume discounts, price discounts, territory discounts. We don't know what the nature of those contents are.
So just tell me one thing, that how many documents are going to be subject matter of the discovery of this?
They'll have to clarify because their agreement, we don't know at this stage.
Do you have any estimate? Because those documents must have been filed.
They said about 50 licenses, man. They said about 50 licenses.
And all 50 documents they are saying are going to be redacted.
That's right. They're saying there will be some clauses which will be redacted. Some clauses will be redacted. Yes. So what we are saying is we proposed a via media. We are not saying we should all have unredacted access. We proposed a via media. We said that at least as lawyers, you give us access to the unredacted portion so that we're able to look at it and see the relevance of it. If there's no relevance, we let it go.
Okay. Anything else?
There's a third aspect as well. The third aspect is they say to us that they will pick and choose these agreements. They will choose what the comparable license agreements are. Now, my lady, what happens in an SEP situation is there may be various implementers. There may be an Apple, there may be a Samsung, there may be a Xiaomi, there may be an Oppo, there may be a Vivo, and so on and so forth. These are all implementers. They are all phone companies. Now, they may have, what they are seeking to file are third-party agreements with other implementers to be able to show that this is what we offered to other mobile manufacturers. Now, my lady, in order that they are able to show that what they've offered to us was FRAND, that is the question that my lady will ultimately determine. Whether the offer, the commercial offer, license offer made to this defendant is FRAND or not, we as parties would be entitled to look at what other comparable entities, like similarly situated like us, were also offered. Now, they are given the ability to pick and choose what commercial agreements or arrangements they will share with us. We are concerned that
that's not part of this prayer. The part of this prayer is only constitution of the confidentiality club.
They clarify that they're going to give us all license agreements. We have no problem. What they are saying is that they will only give us comparable license agreements as they choose. That's what they've indicated to us.
That is because this is their application and they want to rely upon certain documents. What they are not relying upon, this is not your application for discovery.
Yes.
This is their application for showing you confidential documents. So this third aspect of your argument can't be a part of this application. I understand the first two.
Yes.
But how can this discovery is not a part of yours? They are whatever they want to rely upon, they will show you. I understand your redact argument and your pick and choose names and provider.
Yeah, perhaps I was not clear. I obviously wasn't clear.
Yes.
The reason why we are requesting, my lords, to give us access to all agreements is because of their ability to pick and choose and only disclose some agreements.
No, I understood that. But what I'm saying, Mr. Sai Krishna, is that this is their application.
Yes.
They are seeking constitution of a confidentiality club to show you documents that they want to rely upon.
Yes.
But you don't even know what they're going to show you. But you're presuming there are going to be some documents that they're going to withhold.
Maybe.
That will be discovery.
Yes.
So that you will have to move separately. Right now, your concern is about the clauses of confidentiality club which they are proposing.
So I'll just make one more submission in this regard and then I'm done. I'll leave it to my lady. Would my lady please look at Order 11, Rule 12. Rule 1, Sub-Rule 12.
So just give me the PPC. Order 11, right?
Rule 12, Sub-Rule 12.
First one. Yes. Yes.
Duty to disclose documents which have come to the notice of a party shall continue to the disposal of a suit.
Yes.
Here, if their obligation is to be truly FRAND, and if their offer is going to be tested on the angle of FRAND vis-a-vis the offer they made to me, then they are under a duty to produce all third-party license agreements.
Yes, I understand that, but that can be a subject matter of this application.
Very well.
I'm not prejudicing that right or closing your that right.
Please keep that open.
You pursue that right.
Yes.
Can I, yes, you follow me, what your leadership is saying?
Yes.
Leadership will just, observe that this is, preserving our right to seek disclosure
That's right.
in respect of any other document which we may feel is required.
That is anywhere there, no? In the you can make that submission. You just give me your written submissions. You make this submission in that whatever you're reserving a right, I'll deal with that. Okay?
Yes. So that tomorrow, because otherwise we will have to seek a disclosure. But then we'll have to make out a case of what they have referred.
Reserve your right. You reserve your right of disclosure. Just give me a written submission.
The problem with discovery here is I really won't know what they have. I'm completely blindsided.
So it can be, it can be a simple application for discovery. No, you can say that please discover all licenses executed.
Consider keeping that option open.
Yes. So please give me written submissions in 3 pages or whatever you've argued, and I'll deal with it. Okay. Yes.
Let's deal with the last part first, on the matter of my obligation to give to them. Every agreement I've signed, but please note under the brand of friend in no fair, reasonable, non-discriminating. I am only obliged, the onus upon me to persuade your relationship that in fact I have offered reasonable term to them, which I have offered to similarly situated persons, not to everybody in the world. And this question precisely came up with your I want to share a judgment of this court in the case of Erickson versus Joni. Precise question, where
City, why should I deal with it? I'll just simply say when they move it, it will be decided in accordance with law. Why should I get into the question? I'll not foreclose the right, but I'm not going to decide it either. That right, that whether they are entitled to discovery or not, will be decided as and when they move an application. Yes.
Yes. Nonetheless, on my friend's argument of that in some other jurisdiction, there was no restriction placed. Well, I spoke to you, in at least 2 jurisdictions, external experts, in-house experts are not committee. Where the question of granting gateway for them. External expert committee.
This was in which order?
That was in the ITC order. The US court.
Okay. Yes.
Secondly, please also consider the view of the coordinate bench first, deciding, where the court found merit in our contention that the in-house experts should not be there. Because they are the parties who will thereafter go and negotiate with my counterpart and seriously prejudice my competitive advantage. As also the advantage of the counterpart. And please note that the restriction is not quite independent. Only qua the individuals named herein that they personally will not participate in the negotiation team. And the whole purpose is to balance rights. That there is a conflict.
This is a restriction only if they want the internal experts. If they take external experts, this restriction is not possible. Yes.
Numbers on the matter.
Yes.
All these restrictions are only done in terms of balancing rights of your parties. These are very complex agreements, complex rights of parties and on the matter of redacting. Please kindly note.
Yes.
Leadership rightly said to say it is open for them to come and show to leadership to any particular document or all of them. That was something needs preserving disclosure. But then again, redaction is relevant because they are confidential. And we would seek to redact confidential part of the document.
But then he's referring to a judgment that there is a judgment of Justice Hari Shankar that you can't rely upon documents that are redacted.
It in fact says the opposite. I'm giving this judgment. and the leadership has a whole lot of law on the other side to say that redaction is permitted. But please kindly also, the leadership kindly comes back to Delhi High Court. Can just place that. Which kindly has minutes.
Yes.
19 of the Delhi High Court rules. The Delhi High Court rules IPD rules.
So if you have the same textbook, can you tell me the page number?
Just
Chapter?
this chapter 7,
Okay.
rule 17.
All right.
That is page number 38 of the election.
Okay.
At the bottom of the page.
Yes. Yes.
Dinesh, you kindly have it. When the parties to a commercial suit wish to rely upon information that are commercially or otherwise confidential in nature, the court may constitute a club so as to allow peace market limited access to such documents, public information. In so doing, the court may set up a structure protocol for the establishment and functioning of the club that may deem appropriate. Investment structure is so and so. Well, please kindly have it. That structure is set out. And then must please kindly have the IPT rules. Which you will find us in the book, which has page 389.
Okay. Yes.
Please have another sub-rule 1. At any stage in a proceeding, the court may constitute a club or adopt such measures as the visiting of lawyers, external or in-house, experts and also non-representatives, the preservation and exchange of property information by the court. Such non-representative parties appointed to the club may inter alia be persons who are not in charge of or active in the day-to-day business operations and management of the respective parties so as to maintain the integrity of the information so disclosed. And then please have Sapara 2. The court may, upon request made by an application private, redaction of such information, including documents, as it deems to be necessary. And please kindly have us, the President, my friend, Dr. Raja, indicated in this Shankar brief. And please only have us in conclusion on page 56. Just please state your councillor to page 56 of page in the right hand bottom. Paragraph 65. Please straight away come to the second last page.
So which page number?
56.
So I have a different copy. It's a division bench judgment. Okay, just a minute. Yes, sir. Page number? Yes.
There, under the conclusion, 65. And please straight away come to the next page.
Yes.
Second page is later. That's Sapar Roman 8.
Yes.
Neither party were willing to rely on the and the closed classification is should either party either cannot be shown to nominal represent the opposite party. It is at liberty to redact such details of particular document. Needless to say, the party that redacts any particular piece in any document or evidence shall not be able to rely upon such redacted particulars. Shall, however, go to the opposite party to read that disclose such redacted is necessary. In such a case, the court will decide on a document basis whether redacting or confidential, which election is observed and Mr. proposal will be.
Mr. Sai Krishna,
Yes.
is this the judgment you're relying upon of Justice Hari Shankar?
Yes.
So, but then this is willing to accept, no? This
No.
is willing to accept Roman 8.
That's why, in fact, if my lady would look at what the judgment holds, I'll just read it right. Neither party would be permitted to rely on any material which is not disclosed to the nominated representatives as opposed to the advocates and experts of the opposite. Should either party feel that any details contained in any document cannot be shown to the nominated representative of the party, that shall be liberty to redact such details or particulars from the documents in question. Needless to say, the party that redacts any particulars is in any document or evidence shall not be permitted to rely on such redacted particulars. It shall, however, be open to the opposite party to plead the disclosure of such redacted material as necessary for his defense. Now let's pause here for a moment.
If you finish this, then you tell me. Then you finish this para, then we'll see.
In such a case, the court would decide on a document-to-document basis whether redacting of the confidential details of the document should or should not be allowed. This, in my view, is the maximum extent to which the plea of interdiction to keeping away from the representative of Xiaomi confidential details and documents can be accommodated.
Your right is being reserved, no? Even at this stage when the confidentiality.
My lady, please appreciate what I'm saying.
Is this, but you, when you made the submission that there's a judgment of Justice Hari Shankar, you were relying upon this para?
Relying on this paragraph. I'm grateful. But the point I'm trying to make for my lady's consideration is, in view of this paragraph, what we proposed to them was this. Let the external representatives, that's just the lawyers, be given access to an unredacted version. The internal representative will not see it. If there's any portion that's redacted, it will only be the external representatives who will see it. If there's anything that's relevant, potentially relevant to the defense of the defendant, then we will come back to my lady. It is the only way. Otherwise, I will never know what has been redacted. I will never know whether anything that has been redacted is material to my client's defense. That is the point I'm making for my lady's consideration.
Okay, you were a party to this judgment,
Yes.
so you know how this order worked itself out.
Yes.
In this particular matter, once this confidentiality club was formed, were you given, were any redacted documents shown to you?
Full unredacted versions are shown. In fact, my learned friend is here as well.
They did not claim any redacted documents in this.
Be very clear and be sure.
Yeah, my lords, for the parties, that's the defendant who was not part of the club, they gave a redacted version. But for the members of the club, completely unredacted versions.
Matter got settled, the matter could actually go to.
No, matter went to trial and it got settled after.
It went to trial.
After the interim order.
In fact, my lady, these disclosures help in settlements is our experience, because there is a huge trust deficit between two parties when they negotiate as to what is being shown and what is being hidden. In fact, complete transparency of disclosure only promotes a quick settlement wherever possible. That's been our experience. And my ladies, so therefore, just to close this argument, all I'm saying is that if there is anything that is material to my defense, unless I see what it is, unless someone sees what it is, they will never know what is relevant, because it's just completely blanked out. So therefore, we suggested, in the light of this paragraph, that please allow access at least to the external members who are the lawyers. That is us. We are officers of this court. We are part of a confidentiality club. We are sworn to secrecy. We will look at what is unredacted and then make an assessment of whether there could be any potential of the redacted portion.
So you're saying in Roman 8, this judgment allowed the advocates to see the entire document. That's how this was worked out. This document.
Yes. I'm saying something else. Yeah. I'm saying in the light of the fact that the judgment of Justice Hari Shankar says that anything that is redacted, and if there's anything material to the defense of the other side, then on a case-to-case basis, the court will decide. In the light of that finding, what we proposed to the other side was, please permit us as external parties, as external members, to take a look at the unredacted portion.
Okay.
Well, just last. Request if your ladyship may also look at para 30, my lord, 35 of this judgment, where, my lord, the entire reasoning and the thought process of the learned judge has been expressed, and in particular, my lord, in paragraph 31 of this judgment. If I may read, my lord, from second line on page 24, para 31. Equally, it starts with, my lord, equally. Your ladyship has got, my lord. Equally, in fact, I'm not reading the whole thing from para 30, but your ladyship will just mark it, because this all was dealt with in great detail. Equally, Zaumi has the option of rejecting such rates if they are not fair. Zaumi Road is the implementer. In such latter eventuality, if InterDigital seeks to rely on the rates at which licenses have been granted to the other parties, the circumstances in which said licenses were granted have, in my view, necessarily to be made known to Zaumi, and not merely to their attorneys and experts with prescription from disclosing the material to Zaumi's officers and employees, in order for Zaumi to take an informed decision as to whether such licenses are comparable. The rates at which such licenses have been granted are in fact frank, and whether comparison of such licenses, which the rates offered by Zaumi reveals the rate offered by Zaumi not to her friend. And therefore, my lord, the comparable licenses are what we need to know whether, and that's what was being submitted by. If they selectively produce the documents and ask us to look at it, we won't know whether they are comparable or not. But then, according to this judgment, I have a right to know what are the comparable agreements, and they must make those available to us. So that, my lord, either they should tell us give us the list, my lord, of all the licenses they have issued and give us selectively, and your ladyship reserves the right to seek the disclosure, or they may produce all the documents and show it. Okay. And, you know, this chapter 7 to 70, my learned friend read, has been dealt in para 3. So it's already been accounted for in this judgment, in paragraph 3 of the judgment.
One last sentence. We are not going to agree to their substituting any name as what we have proposed. Names of the same gentlemen who were part of the club in the other group. This one last one in terms of the case management. They should have required them to file reply, so as to not make the next hearing only for the time warrant to be effective. Neither of them have filed replies in the requisite time in issue appointed. Plus, in item 47, by an order of 4th of August, has undertaken to file by 20th of August. That should satisfy us. So the other two matters, they've not filed. If they not indicate when they will file. The whole purpose is defeated about the timeline the legislature has set in the previous order.
Just write down separate orders. In item 45 and 46, just say I number 15315 of 2025 and I number 15143 of 2025. Arguments heard and concluded. Then counsel for the parties are directed to file their written submissions, not exceeding 3 pages within 1 week. Okay. In 45 and 46, what is the status of pleadings in the remaining?
They did not file their replies. They did application.
Okay. So what is the status?
We require 3 weeks to file the reply.
What was the time granted to you, sir?
And when that 4 weeks expired, on the 6th of August. And 46 expired on 32. So already the 3 weeks gone by.
Just write In item 45, Learned Counsel for the defendant states that it shall file its reply to IA number 1513 of
की स्टोरी देख
2025
देख के मैं
within
मर
3 weeks. Full stop. Within 3 weeks. Considering that time was initially granted on 2nd July 2025, it is made clear that no further extension will be granted, and in case no reply is filed, the right shall stand closed. Okay. Now, in similar in item 46, what's the IA number in 46?
I will not give them 3 weeks initial time. You may give them those 2 weeks, I at least give them 3 weeks.
Okay. Make it 2 weeks. All right. And in item 46, similarly, there's a 39(1) and 2 application, give 2 weeks in that also. In 47, what is the status?
They will buy by 20 the box.
In item 46, similar direction for IA number 1514 of 2025. Okay. And in item number 47, no directions in that. Okay. Just one. Just list it up the things so that I can see the written submissions. Right? So you file your written submissions within 1 week. Okay. List on. Okay. You can give whatever you want to give to that. Right? Okay.
Very good.
27th August. Item 48.
Actually, it's not possible. Cancel. Item numbers. Okay.